My daughter put papers in front of me. "Mom, sign this. It's just family documents." I trusted her and signed without looking. 6 months later, a letter from court arrived. When I opened the envelope, it turned out I had signed, "Good day, dear listeners. It's Louisa again. I'm glad you're here with me. Please like this video and listen to my story till the end and let me know which city you're listening from. That way I can see how far my story has traveled." I used to wake up every morning to the sound of cardinals outside my kitchen window. That was my favorite thing about the house on Maple Creek Road. The birds. My late husband, Donald, had planted a row of crabapple trees along the fence back in 1987. And every spring, those trees brought half the neighborhood's songbirds right to our yard. After Donald passed in 2019, those birds were my company. I'd pour myself a cup of coffee, always the same chipped blue mug Donald had brought back from a fishing trip in Montana. And I'd sit at the kitchen table and just listen. I was not a lonely woman. I want to make that clear. I had my neighbor Ruth across the street, my book club on Thursday evenings, my garden, my church. I had a routine that held me together like a good seam in a quilt. I was 71 years old, and I knew who I was and what I had. The house was mine, paid off. Donald and I had worked for 40 years for that house. It was not just walls and a roof. It was everything. I also had my daughter Linda. Linda was 52, lived 40 minutes away in Columbus with her husband Craig. She called on Sundays, visited for the holidays, remembered my birthday. I thought we were close. Looking back, I wonder if I ever really knew her at all, or if I only knew the version of her she chose to show me. The first time something felt off, I ignored it. It was a Tuesday in early March, about 8 months before everything fell apart. Linda came by for what she called a quick visit. She brought a casserole, which should have been a warm thing, but there was an energy about her that day. A tightness around her eyes, a way she kept glancing at Craig when she thought I wasn't looking. Craig had come too, which was unusual. He was a quiet man, the kind of quiet that isn't peaceful, but watchful. They walked through the house. That was the strange part. Linda asked to use the bathroom, which was fine, but then she was gone for 10 minutes. And when I went to check on her, I found her in the hallway, looking at the door to the back bedroom, the room Donald had used as his office, the one I hadn't changed since he died. She said she was just remembering old times. I believed her. Why would I not believe her? She was my daughter. Craig asked about the roof. He asked whether the gutters had been cleaned, whether I'd had any trouble with the furnace that winter. He framed it as concern, and I accepted it as concern. Now I understand it was inventory. He was walking through my house the way a buyer walks through a property before making an offer. 3 weeks later, Linda came back alone. She sat down at the very kitchen table where I drank my morning coffee, and she spread out a small stack of papers. She was cheerful, almost breezy. She told me it was nothing complicated, just some family documents, a formality really, things her lawyer had said made sense to have in order now that I was getting older. A healthcare proxy, she said. A simple financial power of attorney, just in case. And one more form, something about the house, she said. Just a transfer on death designation, so that if anything ever happened to me, the house wouldn't get stuck in probate. Mom, it's just paperwork, she said. It protects you. I remember looking at those pages. They were long and dense, full of the kind of language that makes your eyes slide off the page. I remember thinking I should probably read them. I remember thinking I should probably call my own lawyer, a man named Gerald Watts, who had handled Donald's estate. I had his number in the address book by the phone, but Linda was sitting right there, smiling at me the way she used to smile as a little girl when she wanted something, and I thought, this is my daughter. She loves me. Why would she do anything to hurt me? So I signed all 4 documents. Without reading a single page, she gathered them up quickly, gave me a hug that lasted exactly as long as a normal hug, thanked me for the coffee, and drove away. I stood at the window and watched her car disappear around the bend, and for just a moment, only a moment, something cold moved through me. I pushed it away. 6 months later, the letter came. I remember the envelope, plain white, with the Franklin County Court of Common Pleas return address printed in the upper left corner. I remember standing at the mailbox in my slippers on a cold October morning, staring at it. My hands were steady when I opened it. They were not steady by the time I finished reading. The documents I had signed were not what Linda had described. The transfer on death designation was not a designation at all. It was a deed, a warranty deed, transferring full ownership of my home on Maple Creek Road to Linda Marie Harlow Briggs, effective immediately upon notarization, which had happened the same day I signed. My home was no longer mine. According to the Franklin County property records, it had not been mine for 6 months. The court letter was a notice of a civil filing. Linda was seeking a declaratory judgment confirming her ownership. She was not waiting for me to die. She was moving me out while I was still standing in the kitchen. I stood at that mailbox for a long time. The cold came up through my slippers and into my feet, and I didn't move. A car passed on Maple Creek Road and the driver waved. It was my neighbor Dave from 3 houses down, and I lifted my hand automatically, the way you do when the world expects you to be normal, and you have just discovered that the floor has fallen out from under your life. I went back inside. I sat at the kitchen table, my kitchen table, in my kitchen, in my house, except apparently none of those words meant what I thought they meant anymore. I laid the letter flat on the table, and I read it again, and then a third time. Then I went to the cabinet above the refrigerator, where I kept a folder of important papers, and I found the copies Linda had left me. She had left me copies. That struck me later as the most chilling detail, that she had planned carefully enough to leave me copies, because she knew I would need them to understand what I had done, and she had decided that was acceptable. She was not afraid of me understanding. She thought there was nothing I could do. I read every word of those documents that morning. The first was a legitimate healthcare proxy. That part was true. The second was a durable financial power of attorney, but it was not limited the way Linda had implied. It gave her full authority over all my financial accounts, my investments, everything held in my name, effective immediately. Not upon incapacity, immediately. The third document was the deed, a warranty deed, properly witnessed and notarized, transferring the house. And the fourth, the one she had barely mentioned, the one she slipped between the others, was a document revoking a small, revocable living trust Donald and I had set up in 2018. A trust that had held a savings account with just over $40,000 in it. That trust was now dissolved. The account had been transferred to Linda's name 11 days after I signed. $40,000, the house on Maple Creek Road, and the legal power to make decisions about my money and my health care. In 20 minutes at my kitchen table, I had signed away everything. The fear was enormous. I won't pretend otherwise. I sat in that kitchen and I cried. Not soft, dignified crying, but the ugly, gasping kind. The kind where you press your hand over your mouth because you're ashamed of the sound you're making. I cried because of the money and the house, yes. But more than that, I cried because it was Linda, my daughter. The little girl I had driven to soccer practice and stayed up with when she had the flu and walked down the aisle at her first wedding. That person had sat at this table and lied to my face and taken everything I had, and she had done it carefully, patiently, with a casserole in her hands. How do you grieve something like that while you're still in the middle of it? But here is what I knew about myself, even sitting there shaking. I was not a woman who collapsed. Donald used to say that about me. He'd say, "Betty, you are the least collapsible person I've ever met." He meant it as the highest possible compliment. And I thought about him saying that, and I wiped my face with a dish towel, and I made myself a second cup of coffee. Then I started thinking. The first thing I needed was information. Not assumptions, not panic. Information. So I went to the address book by the phone, and I found Gerald Watts's number. Gerald had handled Donald's estate. He was a probate and estate attorney in Westerville, a serious man in his 60s who did not waste words. I called his office. His assistant said he was in a deposition but could return my call that afternoon. I left my number. While I waited, I thought about what I knew. I knew I had signed the documents. That was the central problem. Linda would argue, and clearly was already arguing, given the court filing, that I had done so knowingly and voluntarily. She had a notarized deed. She had my signature. In the eyes of a court, that was a powerful thing. But I also knew something else. I had not read those documents. I had not been given time to read them. I had not been advised to seek independent counsel. And Linda had specifically described the documents in ways that were false. She had called the deed a transfer on death designation, a completely different legal instrument with completely different consequences. She had called the power of attorney a limited document. She had misrepresented every single page. That was fraud. I didn't know the legal term yet, but I knew what the thing was. When Gerald called back at 4 o'clock that afternoon, I told him everything. I kept my voice steady. I described the signing. I described what Linda had said. I told him about the court notice. There was a pause when I finished. "Betty," he said, "I need you to bring those documents to my office tomorrow morning, all of them, and don't contact Linda. Don't call her, don't respond to anything from her, and absolutely do not let her or Craig into this house. Can you do that?" "Yes," I said. "Good. We may have a case for undue influence and fraudulent misrepresentation. It's not simple, but it's not nothing." Not nothing. I wrote those 2 words on the notepad beside the phone. That night I did not sleep, but I did not cry again either. I lay in the dark in the bedroom I had shared with Donald for 38 years, and I made a list in my head of everything I remembered about the day Linda had come with those papers. Everything she had said, word for word, every expression on her face, every detail I could recover. I was building something. I didn't know yet exactly what it would become, but I knew it had to be built carefully, from the ground up, with nothing left to trust but facts. Gerald Watts's office was in a low brick building on State Street in Westerville, between a tax preparer and a dry cleaner. I had been there only once before, after Donald died, and the waiting room smelled exactly as I remembered. Old paper and carpet cleaner and faintly, coffee. I arrived at 8:50, 10 minutes early, with a manila folder containing the 4 documents and the court notice. I had also brought the notepad from beside my phone, with the notes I had made the night before. I was not going to go into this room unprepared. Gerald reviewed everything for nearly 40 minutes while I sat across the desk from him. He made notes on a legal pad. He asked me questions. Precise, methodical questions about the timeline, about what Linda had said verbatim when she presented each document, about whether anyone else had been present, about whether I had felt pressured, about the state of my health and my cognition, about whether I had ever before discussed giving Linda authority over my affairs. I answered every question as specifically as I could. When he looked up, his expression was careful, but not without hope. "The deed is the central problem," he said. "Under Ohio law, a warranty deed executed with your signature and properly notarized carries significant legal weight. Linda has that going for her, but what she doesn't have is clean hands." He explained that a deed can be challenged on grounds of fraud in the inducement, meaning that if someone secures your signature By deliberately misrepresenting what you're signing, the document may be voidable. You signed believing this was a transfer on death designation, he said. That is a materially different instrument. If we can establish that Linda described it as something other than what it was, we have an argument. She called it a transfer on death designation at least twice, I said. Those exact words. Do you have any record of that? Texts, emails, anything written? I did not yet. Gerald filed a motion to intervene in the civil proceeding Linda had initiated, essentially entering my appearance as a defendant with counterclaims. He also filed an emergency motion to freeze any further transfer or encumbrance of the property while the case was pending. The judge granted the freeze within 48 hours. The house, at least, could not be sold out from under me while we fought. That was the first thing that felt like solid ground. Now, what Gerald needed and what I needed was evidence. I went home and I did something I had never done before. I went through my phone, my old iPhone that Linda had helped me set up 2 years ago, and I read every text message she had ever sent me. I was looking for anything related to the documents. And on February 28th, 11 days before the signing, I found it. A text from Linda. Short, casual, the way she always wrote. Mom, just so you know, I'm having some estate planning paperwork drawn up to protect you in case anything happens. Gerald Watts stuff, but simpler. Nothing to worry about. Gerald Watts stuff. She had used his name, my own lawyer's name, to make the documents sound familiar and legitimate. She had deliberately invoked the name of a professional I trusted. I photographed that text message. Then I forwarded it to Gerald. He called me within the hour. This is significant, he said. She represented these documents as equivalent to work done by your own attorney. That's a deliberate misrepresentation designed to induce your trust. Keep looking. I kept looking. In my email, which I used far less often but Linda had helped me set up as well, I found a message from 3 months before the signing. Linda had written, asking whether I had ever thought about simplifying things with the house, and mentioning that it might be easier to have the property in both our names. I had replied, briefly, that I hadn't really thought about it. She had written back, "That's fine, no rush. Let's just talk sometime." She had been planning this for at least 5 months before she brought those papers. The picture that assembled itself in my mind was not one of impulse or desperation. Linda and Craig had planned this methodically. They had assessed the house. They had laid verbal groundwork. They had chosen a moment, a quiet Tuesday, when I was alone, when I was trusting, when I was perhaps a little lonely. And they had moved. It was that cold deliberateness that was hardest to hold in my mind. But then something else happened that pushed everything past the point of doubt. On the 4th day after my first visit to Gerald's office, I got a call from a woman named Patricia Osley. She was a notary who worked out of a UPS store on Cleveland Avenue. She said she had been contacted by an investigator working on behalf of Gerald Watts, and she wanted to speak with me directly. She was clearly nervous. She said she had notarized the deed. She remembered it clearly because of what had happened. "When your daughter brought you in," Patricia said, "you asked her what you were signing. I heard you ask. And she said, 'I remember because it stayed with me.' She said, 'Mom, it's just the death document, the one so the house doesn't get stuck.' And then she put her hand over yours on the pen, on—" I had not remembered that moment consciously. But as Patricia said it, it came back to me. The warmth of Linda's hand over mine, the slight pressure, the sense of being guided. "I should have stopped the signing," Patricia said. "I knew something felt off. I've thought about it a lot. I'm sorry I didn't say something." She agreed to provide a sworn statement. I sat in my car in the parking lot of a CVS after that call, and I looked out at the gray Ohio sky, and I thought, she put her hand over mine on the pen. My own daughter. I thought I had understood what had been done to me. But it was not until that moment Not the legal facts, not the financial loss, but that single physical image, her hand over mine, that I understood it completely. I called Gerald and told him about Patricia Osley. "Betty," he said, and there was something in his voice that had not been there before. "I think we can win this." The legal process moved the way legal processes do, not quickly, but with a kind of gathering weight. Gerald filed our formal counterclaims in the second week of November. Fraudulent misrepresentation, undue influence, and a demand for rescission of the deed and revocation of the power of attorney. He attached Patricia Osley's sworn statement and the screenshots of Linda's text and email. He also filed a request for the full notarization file from the UPS store on Cleveland Avenue and a subpoena for Linda and Craig's financial records. Specifically, he wanted to see whether they had been in financial difficulty around the time of the signing. "People don't do this unless something is pressing on them," Gerald told me. "There's usually a reason." He was right. Within 10 days, the subpoenaed records told a clear story. Craig's contracting business had taken out a substantial second business loan 18 months earlier. The loan was delinquent. They had a home equity line of credit that had been drawn to its limit. The Columbus house, the one Linda and Craig lived in, had its own mortgage, and they were behind on payments. They had been drowning, and they had decided my house was their life raft. Knowing this helped me, in a strange way. It didn't forgive anything, but it made the shape of the thing visible. They had not done this out of pure cruelty. They had done it out of panic, which is somehow worse, because panic is something human. It meant Linda had weighed her mother's security against her own and chosen herself. I don't know which version of that fact is harder to live with. The call came on a Thursday morning, 3 days after the counterclaims were served. I was in the garden, late November, cold, but I'd gone out to cut back the last of the dried perennials because moving around helped me think. When my phone rang. It was Linda. I had been expecting this. Gerald had told me she might call. He had also told me not to engage, to end the call and document the contact. I answered anyway. I know that's not what I was supposed to do, but she was still my daughter. "Mom!" Her voice was tight. "What are you doing?" "I'm protecting myself," I said. "You're destroying the family." She was crying, or close to it. "Craig and I are in real trouble. You know that. We needed help. We were going to pay you back. We were going to figure it out. But you're making this into something ugly, and it doesn't have to be." "You transferred my house, Linda, without telling me what I was signing. You knew. Patricia Osley heard you tell me it was a death document." Silence, a long silence. "That woman doesn't know what she's talking about," Linda said, and her voice had changed. The grief was gone, replaced by something flat and deliberate. "She's going to say she misheard. She's going to reconsider. And those texts you dug up? A lawyer can read those 100 different ways. You're 71 years old, Mom, and you're about to spend the last years of your life in court, fighting your own daughter over a house you can barely maintain. Is that really what you want?" It was, I realized, a threat about Patricia, and a threat about my age. The implication that I was too old, too fragile, too unreliable to be taken seriously. It was designed to be demoralizing, and it was partially effective. I felt a tightening in my chest that had nothing to do with the cold. "This conversation is over," I said, and I ended the call. I documented it immediately. Time, duration, what she had said. I sent that documentation to Gerald within the hour. But they weren't finished. 4 days later, Craig came to the house. He knocked on the door on a Sunday afternoon while I was having lunch. I looked at him through the glass panel beside the door, and I did not open it. He stood on my porch for 11 minutes. I know because I timed it. And then he left a note in the mailbox. The note said that they had evidence, that I had been showing signs of cognitive decline for over a year, and that if the case went forward, they intended to call a doctor to testify to my mental incompetence at the time of signing. They said they had emails from me that showed confusion. They said a guardian ad litem might be necessary. I stood in my hallway and read that note, and I felt the fear move through me like cold water. A competency challenge. That was their weapon. The implication that I had not understood what I was signing, not because I had been deceived, but because I was mentally failing. If they could plant that seed with a court, if they could find any doctor, any piece of evidence, any moment of ordinary human forgetfulness to weaponize, they could undermine everything. I called Gerald. He told me to come in the next morning. When I arrived, he was calm. A competency claim is a double-edged sword, he said. If they argue you lacked capacity, they also undermine the validity of the deed. You can't have it both ways. Either you understood what you signed and were defrauded, or you didn't understand, in which case the document is invalid on those grounds. We'll let them make that choice and make them answer for it either way. He also told me to see my doctor immediately and get a clean cognitive evaluation on the record. I did. My doctor of 15 years, Ann Kowalski, saw me 2 days later. The evaluation was thorough and the results were what I had expected. No signs of cognitive impairment, full decision-making capacity, good memory. Dr. Kowalski documented everything carefully. When I left her office, I sat in the parking lot for a moment. The threat about my mind had been the cruelest thing they had tried, worse than the money, almost worse than the house, because it had aimed at something more fundamental. It had tried to erase me as a person capable of defending herself. It had failed. I went home, fed the birds, ate dinner, watched a quiet hour of television, and went to bed at 9. The next morning, I woke to the cardinals in the crabapple trees, and I felt, for the first time in weeks, something that was not quite peace, but was the shape of peace, a space where peace could eventually live. I gave myself 3 days. I read novels. I called Ruth across the street and had dinner with her. I did not think about the court case. I let my mind rest so it could be sharp when I needed it again. I was going to need it soon. The offer came through Linda's attorney. It arrived as a formal letter to Gerald's office on a Monday in early December. Clean stationery, careful language. But the substance of it was as transparent as if Linda had written it herself on a paper napkin. They proposed to return the power of attorney and agree to certain conditions on the deed in exchange for my dropping all counterclaims and signing a document stating that the original transaction had been voluntary and fully understood. In other words, abandon the case, say publicly that I had not been deceived, and in exchange receive a modified arrangement that still left Linda with significant legal claim to the house. Gerald brought me the letter in person and set it on the desk between us without comment, which was his way of letting me read it without being influenced by his reaction. I read it twice. "No," I said. "I thought so," he said. "I wanted you to see it before I responded." "What does this mean, them making this offer?" "It means their case is weaker than their initial posture suggested. Patricia Osley's statement is worrying them. The financial records are worse for them than they expected. And the competency gambit." He paused. "I think they've been advised that it's a high-risk strategy that could backfire significantly in front of a sympathetic judge." "So they're scared," I said. "They're recalculating," he said, "which is a kind of fear." I told him to decline the offer and to do so briefly, without elaboration. I didn't want them to know how I felt. I wanted them to have nothing to calculate with. What I felt, if I'm being precise, was a stillness I had not expected. I had anticipated this moment. Some version of it. Some attempt to make this all go away quietly on their terms. and I had thought I might feel tempted. The case was exhausting and expensive and painful in ways that had nothing to do with money. A part of me still grieved my daughter. A part of me would have given almost anything for a different story. One in which Linda had simply come to me and said, "Mom, we're in trouble. Can you help us?" And I had said yes, because I might have. I probably would have. But that was not the story we were in. The story we were in was one where she had chosen not to ask. She had chosen instead to take, quietly and carefully, while I wasn't looking. And then, when I stood up, she had tried to tell me I was too old to stand. There was no offer they could make that would undo the shape of those decisions. I went home that afternoon and called Ruth. Ruth Delacroix had been my neighbor for 23 years. She was 74, sharp as a wire, a retired high school history teacher who had survived a difficult divorce in her 50s and came out of it, in her own words, mean enough to be kind. She was the one person outside of Gerald who knew the full situation, because I had told her everything over her kitchen table the week before, over pot roast and green beans, because I needed to say it out loud to someone who loved me and would not tell me what I wanted to hear. She had listened without interrupting, and when I finished, she had said, "Betty, you are going to fight this, and you are going to win, and I am going to be with you every step of the way." I had believed her. Now I called her and told her about the settlement offer and my answer. "Good," she said without hesitation. "They can keep their offer." Ruth did something in the following weeks that I hadn't asked for and couldn't have anticipated. She talked to people. She talked to Diane, who was in our book club, whose son was a family law attorney in Cleveland. She talked to the pastor at our church, who had apparently dealt with a similar family situation among his congregants and had thoughts. She told enough people, carefully and discreetly, that within 2 weeks I had received 3 phone calls from women in the community, 2 older widows and 1 woman in her 50s, who had been through elder financial abuse cases of their own in varying forms. They offered their experiences, their lawyers' names, their presence. One of those women, a quietly determined 78-year-old named Helen Marsh, had won a case against her own son 5 years earlier. She had been through the competency accusation, the isolation, the settlement pressure. She had come out on the other side with her house and her dignity intact. She met me for coffee at a diner on Schrock Road on a Thursday afternoon. "The worst part," Helen told me, "is when you start to wonder if they're right. If you are too old, too naive, too trusting. If you deserved it somehow." "Yes," I said. "You didn't," she said. "And neither did I. Being trusting is not a character flaw. It's what they're counting on. And when you stop being naive without stopping being decent, that's when they lose." I drove home in the early dark of a December afternoon and thought about what she had said. Linda and Craig were watching. I knew they were watching. For signs of weakness, hesitation, a second visit to the bargaining table. Gerald had said as much. They expected, I think, that time and expense and emotional wear would slowly erode my resolve. They had miscalculated what I was made of. They came on a Saturday in mid-December, 2 days before the case was scheduled for a preliminary hearing. I was in the kitchen cutting apples for a pie when I saw Linda's car turn onto Maple Creek Road. I put down the knife and stood at the window and watched them park. They came to the door together, Linda in a blue coat I hadn't seen before, Craig in a dark jacket, both of them wearing the careful, neutral expressions of people who have rehearsed their faces. I opened the door. I did not invite them in. "Mom," Linda said, and her voice had found its way back to something soft. "Can we please come in? It's cold and we just want to talk. No lawyers, no, just us. Family." I looked at her. I looked at Craig, who was standing slightly behind her, his hands in his pockets, his eyes moving once, quickly, to the window of the living room. "Say what you need to say from here," I said. Linda's composure bent slightly. Mom, this is humiliating. The neighbors. I don't especially mind, I said. She exhaled and shifted her weight. Then she began. And it was, I'll give her this, a skillful performance. She said she was sorry. Not for taking the house, not in any specific way, but sorry that things had gotten so complicated. Sorry that I had been hurt. Sorry that it had come to this. She said Craig was trying to get the business restructured. She said they were working hard. She said she had made a mistake in how she'd approached the whole thing, that she should have talked to me first, that she knew that. But Mom, she said, this lawsuit is going to cost you everything. Gerald Watts is going to charge you $60,000, $70,000 before this is over. You're going to spend down your savings fighting over a house that I was going to give back to you anyway. Eventually, after you got stable, I repeated. Yes, and when was I going to be told about this plan? She hesitated. You transferred the house in April, I said. It is now December. In 8 months, you filed a civil action to confirm your ownership. That is not someone who was planning to give the house back. Craig spoke for the first time. His voice was flat, businesslike. Betty, we're trying to avoid a situation that gets ugly for everyone. You don't want your daughter's marriage and business to be destroyed over a piece of property. You should have thought of that before you took it, I said. Something shifted in Craig's face. The patience, the manufactured patience, cracked slightly. You're making a mistake, he said. There are aspects of your situation that are going to come out in discovery that you won't want public. Things about Donald's estate that may not reflect well on how the finances were managed. We're not looking to go there, but if this continues... I looked at him calmly. Are you threatening me? I'm advising you, he said. Whatever is in Donald's estate is in the records Gerald Watts prepared and filed with the probate court, where anyone can read them. There is nothing there. I paused. Is there anything else? Linda made one more attempt. Her eyes filled with tears, real ones, or near enough that I couldn't tell the difference, and perhaps it didn't matter. Mom, I'm your daughter. Whatever I did wrong, and I know I did, I am still your daughter. If you do this, you will destroy any chance of us ever having a relationship again. Is a house worth that? I stood in my doorway, and I looked at my daughter, and I felt the love and the grief and the anger all at once, layered on top of each other, inseparable. And I thought, she is asking me to pay for her theft with my silence, and call it mercy. You made that choice in April, I said, when you put a pen in my hand. I closed the door. I stood in the hallway for a moment. My hands were shaking. I won't pretend they weren't. Craig's reference to Donald's estate, the implication that there was something questionable there, had landed. It was baseless. I was nearly certain of that. But nearly certain is not the same as certain. And I was not so composed that I couldn't be frightened. I called Gerald from the hallway and told him about the visit. I told him about Craig's comment regarding Donald's estate. Gerald told me he wasn't surprised and that this was a pressure tactic. They were looking for anything to make me uncomfortable enough to settle. Document the visit, he said. Time what was said. We may be able to use Craig's comment about aspects of your situation as evidence of intimidation. I documented it. Then I went back to the kitchen. The apples were still on the counter, already sliced, already starting to brown. I finished making the pie. I turned on the oven. I rolled out the crust. I did the ordinary things of an ordinary Saturday. And with each movement, I felt the fear settle into something harder and more useful. They had come to my door to frighten me into giving up. They had given me exactly what I needed to keep going. The hearing was scheduled for a Tuesday in January in a courtroom on the 4th floor of the Franklin County Courthouse. I wore the blue wool dress I had worn to Donald's retirement dinner 20 years earlier. I don't know exactly why that detail mattered to me. Perhaps because Donald had always said I looked capable in it. Not beautiful, particularly, though he said that too, but capable. Like someone who could handle whatever came next. Gerald sat beside me at the plaintiff's table. He had spent the previous 2 weeks deposing Linda and Craig separately, and he had told me, without much elaboration, that the depositions had raised certain inconsistencies. I had learned, over the months of working with him, that when Gerald used measured language like raised certain inconsistencies, he meant something had gone significantly wrong for the other side. Linda and Craig arrived with their attorney, a younger man named Ferris, who wore expensive shoes and had the confident manner of someone who has not yet lost enough cases. They sat at the opposite table. Linda caught my eye once, briefly. I held her gaze and she looked away first. Judge Patricia Abrams was in her late 50s, with an expression of permanent, thoughtful skepticism that I found, frankly, reassuring. She read the case summary without apparent emotion, asked both attorneys to confirm the issues in dispute, and then the hearing began. Gerald's first witness was Patricia Osley, the notary. Patricia took the stand quietly, a compact woman in her 50s who had clearly thought carefully about what she was going to say and had decided to say all of it. She described the afternoon of the signing, the UPS store, the light at that hour, the position of the people at the table. She described what she had heard Linda say. She confirmed, under oath, that she had observed Linda cover my hand with her own when I appeared to hesitate. She confirmed that I had asked directly what I was signing and that Linda had said, "The death document, the one so the house doesn't get stuck." Ferris cross-examined her for 30 minutes. He challenged her memory, her angle of view, the noise level in the store. Patricia answered every question clearly, without agitation, without looking at anything except him. When he suggested she might have misheard, she said, "I was standing 18 inches away, and there was no music or conversation nearby. I did not mishear." The second piece of evidence was Linda's own deposition testimony, specifically a section Gerald read aloud into the record. In her deposition, Linda had stated under oath that she had fully explained the nature of each document to me before I signed. She had also stated that she had not used the phrase transfer on death at any point. Gerald then read Linda's own text message into the record, the February 28th message sent to my phone, in which she described the documents as estate planning paperwork and specifically referenced Gerald Watts stuff. He then asked the judge to note that the documents had not been prepared by Gerald Watts, had not been reviewed by Gerald Watts, and were in fact drafted by Ferris's own firm at Linda and Craig's direction. The contrast between what Linda had texted and what Linda had testified was visible on every face in the room. Then Gerald called Linda herself. She took the stand with her composure assembled carefully around her, and for the first 20 minutes, she held it. She was articulate. She was plausible. She projected the measured sadness of a daughter whose good intentions had been misunderstood. But Gerald was patient and precise in a way that did not allow for the performance to sustain itself indefinitely. He asked her when she had first contacted the law firm that drafted the deed. She said she didn't remember exactly. He produced a billing record showing first contact in November, 5 months before the signing. So the planning for these documents began 5 months in advance, Gerald said. Not a question. He asked her to explain Craig's comment on the doorstep in December about aspects of Betty's situation that might not reflect well. She said she didn't know what he meant. Gerald produced my documentation of the visit. Date, time, exact words as I had written them within the hour. He asked whether Craig had been trying to intimidate me into dropping the case. Ferris objected. Judge Abrams allowed the question with a modification. Linda said Craig was concerned and frustrated. Then Gerald asked, "Mrs. Harlow Briggs, when you placed your hand over your mother's hand at the moment of signing, what were you communicating to her?" A silence. "I was being supportive," Linda said. "The notary testified that your mother appeared to hesitate before signing. Is that correct?" She may have. I don't remember her hesitating." "The notary does. The notary was 18 inches away." He paused. "When your mother hesitated and asked what she was signing, did you describe the deed accurately?" "I described it in general terms." "Did you use the words transfer on death?" "I may have, in a general sense." "Your earlier testimony states, and I quote, 'I did not use the phrase transfer on death at any point.' Those are your words under oath. So which is it? You may have used the phrase, or you did not use it at any point." Linda looked at Ferris. Ferris did not look back at her. He was writing something on his legal pad with great focus. "I'm not sure," Linda said. Judge Abrams looked up from her notes. Craig's testimony was, if anything, worse. He was a man who functioned well when in control of a situation and visibly poorly when he was not. Under Gerald's questioning about the financial state of the contracting business at the time the deed was drafted, he contradicted two statements from his earlier deposition. He initially denied that the business loan was delinquent at the time of the signing, and Gerald read him the bank records. He said he had not been significantly involved in arranging the documents, and Gerald produced 3 emails from Craig to the drafting attorney giving specific instructions. By the time they stepped down, the architecture of the story Linda and Craig had constructed had developed too many visible seams. Judge Abrams did not rule from the bench. She took the matter under advisement, which is the customary thing. But she said, before adjourning, that she had significant concerns about the circumstances under which the deed was executed, and that she intended to review the evidence with particular attention to the credibility of the testimony presented today. Gerald and I walked out of the courthouse into the cold January air, and I stood on the steps and breathed. "How are you feeling?" he asked. "Like someone who has been carrying a very heavy thing for a long time," I said, "and can finally see the table where she's going to set it down." Judge Abrams issued her ruling 22 days later, on a Thursday morning in February. Gerald called me before 8 o'clock. I was already awake. I had barely slept. And I was sitting at the kitchen table with my blue mug and the cardinals outside the window, the way I had sat on so many mornings in so many different states of fear and resolve and exhaustion. I heard his voice before he said the actual words, and I knew from the tone. We had won. The ruling was 31 pages, and Gerald emailed it to me as an attachment, and I read every word. Judge Abrams found that the warranty deed had been executed under fraudulent misrepresentation. Specifically, that Linda had deliberately described the instrument as a transfer on death designation in order to induce my signature, and that this misrepresentation was material and intentional. She found Patricia Osley's testimony credible and consistent. She found Linda's testimony, particularly the contradiction regarding the transfer on death phrase, to be not credible. She found Craig's testimony about his involvement to be evasive and inconsistent with the documentary evidence. The deed was rescinded. Full ownership of the property at Maple Creek Road was returned to me, effective immediately. The durable power of attorney was revoked. The dissolved trust was reinstated, with an order compelling Linda to return the transferred funds with interest, $41,200 and some dollars, by the time the calculation was completed. Gerald filed a motion for attorney's fees on the grounds of bad faith litigation, and Judge Abrams granted a substantial portion of it. The amount Linda and Craig were ordered to pay toward my legal costs was not the full amount, but it was significant. Gerald told me that was relatively unusual and reflected the judge's assessment of the conduct involved. Linda and Craig appealed. Gerald told me to expect that and not to be alarmed. The appeal was filed in March and decided by the Ohio Court of Appeals in October of that same year. The appellate panel affirmed Judge Abrams's ruling in its entirety in a 12-page opinion that described the original transaction as a textbook case of elder financial exploitation. 12 pages. I read those 12 pages more than once. The appeal cost Linda and Craig additional attorney's fees, of course. Their own, since the appellate court did not shift further costs. By that point, Craig's contracting business had filed for Chapter 11 bankruptcy protection. The Columbus house went on the market in August. I read about the listing on a real estate website, the way you can now, and I saw the photographs of the rooms, the kitchen, the living room, the backyard where my granddaughter Maya had once had a swing set, and I felt something complicated that I don't have a clean name for. Grief, partly. Something like relief, partly. A kind of exhausted finality. Linda called me once in September after the appeal was decided. She didn't apologize. I want to be accurate about that. She said she wanted me to know she didn't hate me. She said Craig had pushed harder than she should have let him. She said she thought about the day she brought those papers to the kitchen table, and she wished she could go back to it. I listened. I didn't say much. At the end of the call, I told her that I hoped she found a way to build a stable life, and I meant it in the way you can mean something and still know that it doesn't change the shape of what happened. She didn't call again. I filed a complaint with the Franklin County Adult Protective Services Unit as part of the process. Gerald advised this as a matter of record. The case was documented as substantiated elder financial abuse. That documentation existed now in official records, separate from anything Linda could revise or reframe. And on a cold February morning, almost exactly a year to the day after the letter from the courthouse arrived in my mailbox, I stood again at that mailbox, not to receive anything frightening, just to collect the ordinary mail, a utility bill, a seed catalog, a birthday card from Ruth. I stood there for a moment in the cold, holding those ordinary things, and looked up at the crabapple trees Donald had planted along the fence, bare now in the winter, but there, rooted, still there. The house was mine. It had always been mine. It had been temporarily, terrifyingly taken from me by someone I had trusted with my heart. But it was mine now, in the way that a thing is yours after you have had to fight for it. Not the innocent, unconsidered ownership of someone who has never been threatened, but the clear-eyed, hard-won ownership of someone who looked at what she had and decided it was worth defending. I went inside, poured a cup of coffee in the blue Montana mug, and sat down at the kitchen table. And for the first time in a very long year, I simply sat there. And it was enough. Spring came to Maple Creek Road the way it always did, slowly, then all at once. The crabapple trees bloomed in April, later than usual, as if they too had needed extra time to recover. I was in the garden when the first blossoms opened, turning over the soil along the fence, and I noticed it, the way you notice something you have been waiting for without quite admitting it. I stood and looked at those trees for a long time. I had made some changes to the house over the winter. I had the roof inspected, something I'd been putting off since Donald died. I painted the front door a deep green I had been thinking about for 2 years, but hadn't permitted myself during the legal fight. Ruth said it made the house look alive. Ruth and I had dinner together most Thursday evenings now. What had happened over the past year had changed our friendship into something denser and more honest. She was the person I called when something was good as well as when something was frightening. Helen Marsh, who had won her own elder abuse case 5 years earlier, asked whether I'd be willing to speak at a senior advocacy event. I said yes. I stood in a library community room in Clintonville in May and spoke to about 40 people, mostly older women, some adult children, a few social workers. I said I was just a woman who had planted tomatoes in the same backyard for 30 years and had almost lost it because I trusted a signature. That protecting yourself is not the same as not loving someone. A woman in the front row cried. Afterward, she told me her sister had done something similar with their mother's savings. I gave her Gerald Watts's number. Maya, my granddaughter, came to visit in July. We sat in the garden and talked carefully around the subject of her mother for a while, and then we stopped being careful. "I'm angry at her," Maya said. "I need you to know that." "You're allowed to be angry at her and still love her," I said. "Those things can coexist." She stayed for the weekend, came back in September, and October too. She was becoming one of the great gifts of this chapter of my life. As for Linda and Craig, Craig's business had not recovered from the bankruptcy. The Columbus house sold in a short sale, leaving them with nothing. They were renting an apartment in Dublin. I did not feel satisfaction at those facts. Something more like the neutral awareness of a natural consequence, the way you feel watching rain wash mud off a path. The Adult Protective Services documentation existed. The appellate court's description of elder financial exploitation existed. Whether Linda had privately reckoned with what she had done, I couldn't know. That reckoning, if it came, would be between her and whatever she consulted when she needed to be honest. On a Tuesday evening in late October, I came inside from the garden at dusk, washed my hands, and made dinner. I sat at the kitchen table and looked around. The blue mug on its hook, the crabapple trees dark against the sky, the worn place on the floor where Donald had stood 10,000 times. I was still here, still myself. I had not been made smaller by what had happened, and I had not been made cruel by it either. I was just a woman in her kitchen, in her house, on her road, eating dinner as the stars came out. It was more than enough. If this story has taught me anything, it is this. Love and vigilance are not opposites. You can trust your family and still read what they hand you. You can love your daughter and still pick up the phone and call your own lawyer. Being cautious is not the same as being cold. I signed those papers because I believed that love made reading unnecessary. I was wrong, and I was lucky enough to survive being wrong. What would you have done in my place? Would you have signed? If this story moved you, please leave a comment and subscribe. It means more than you know. Thank you for listening.